Rabat, Namaste, Kamusta, Shalom, Salam Alaikum. Welcome. Wanted to share something with you real quick. I'm gonna put it on and let it play. Let's go. Let's take it from here. What banks don't want you to know. Because this is a section called What Banks Don't Want You to Know from the Redemption Manual 4.5. You know what I mean? But check it out. I'm gonna do some of the Google searches. You know what I mean? Pull up some words maybe in the fourth edition of the Black's Law, but I'm gonna play it. Or let the
What
AI
banks
say it.
don't want you to know. The fate of companies, individuals, and governments is entirely at the mercy of bankers. Their power is unbridled, both in the creating and granting of loans, and also in their arbitrary recall, with or without notice. The following quote taken from the Civil Servants Yearbook, the organizer of January 1934, makes their intent all too clear. Capital must protect itself in every way, through combination and through legislation. Debts must be collected and loans and mortgages foreclosed as soon as possible. When, through a process of law, the common people have lost their homes, they will be more tractable and more easily governed by the strong arm of the law, applied by the central power of wealth, under control of leading financiers. People without homes will not quarrel with their leaders. This is well known among our principal men now engaged in forming an imperialism of capital to govern the world. By dividing the people we can get them to expand their energies in fighting over questions of no importance to us except as teachers of the common herd. Thus by discreet action we can secure for ourselves what has been generally planned and successfully accomplished. The Bankers' Manifesto. The Bankers' Manifesto ties in with so-called United States Senate document House Joint Resolution, HJR, 192, 73rd Congress, First Session, Chapter 48, June 5, 1933, to wit, the ultimate ownership of all property is in the state. Individual so-called ownership is only by virtue of government, i.e., law, amounting to mere user and use must be in acceptance with law and subordinate to the necessities of the state. House Joint Resolution explaining what the bankers don't want you to know about the realities of modern-day finance may shatter most of the public's religiously held assumptions about money and banking. What the general public thinks it knows about money and banking is largely based upon a collection of canards gleaned from TV, radio, newspapers, and their own personal experiences with money and banking. In the following pages you will find where high bank officials admitted that bankers do create checkbook deposit credits to the credit of their clients' checking accounts, as their loans and investment payment funds. You will also learn how an attorney has successfully voided a bank foreclosure because the banker admitted to creating the checkbook credits as the funds it loaned to its client. Redemption Manual, 4.5 edition 184. In the landmark court decision which follows, a Minnesota trial court held the Federal Reserve Act to be unconstitutional and void, the National Banking Act to be unconstitutional and void, and declared a mortgage acquired by the First National Bank of Montgomery, Minnesota in the regular course of its business, along with the foreclosure and the sheriff's sale to be void. This decision, which is legally sound, has the effect of declaring all private mortgages on real and personal property, and all U.S. and state bonds held by the Federal Reserve, national and state banks, to be null and void. This amounts to an emancipation of this so-called nation from personal, national and state debt purportedly owed to this banking system. Every so-called American owes it to himself, his so-called country, and to the people of the world, for that matter, to study this decision very carefully and to understand it, for upon it hangs the question of freedom or slavery. On May 8, 1964, Mr. Jerome Daley executed a note and mortgage to the First National Bank of Montgomery, Minnesota, which is a member of the Federal Reserve Bank of Minneapolis. Both banks are privately owned and are a part of the Federal Reserve banking system. In the spring of 1967, Mr. Jerome Daley was in arrears $476 in the payments on this note and mortgage. The note was secured by a mortgage on real property in Spring Lake Township in Scott County, Minnesota. The banker foreclosed by advertisement and bought the property at a sheriff's sale held on June 26, 1967. Mr. Jerome Daley made no further payments after June 26, 1967 and did not redeem within the 12-month period of time allotted by law after the sheriff's sale. The bank brought an action to recover the possession of the property to the Justice of the Peace Court at Savage, Minnesota. The first two justices were disqualified by affidavit of prejudice, the first by Mr. Daley, the second by the bank, and a third judge refused to handle the case. It was then sent, pursuant to law, to Martin V. Mahoney, Justice of the Peace, Credit River Township, Scott County, Minnesota, who presided at a jury trial on December 7, 1968. The jury found the note and mortgage to be void for failure of a lawful consideration and refused to give any validity to the sheriff's sale. Verdict was for Mr. Daley with costs in the amount of $75. The acting president of the bank, Mr. Lawrence V. Morgan, admitted that the banker created the money and credit upon its books by which it acquired or gave as consideration for the note, that this was standard banking practice, that the credit first came into existence when they created it, that he knew of no United States statutes which gave them the right to do this. This is the universal practice of these banks. Mr. Lawrence V. Morgan appeared at the trial on December 7, 1968 and was perceived to be candid, open, direct, experienced, and truthful. He testified to 20 years of experience with the Bank of America in Los Angeles, the Marquette National Bank of Minneapolis and the plaintiff in this case. He seemed to be familiar with the operations of the Federal Reserve System. He freely admitted that his bank created all of the money or credit upon its books with which it acquired the note and mortgage of May 8, 1964. The credit first came into existence when the bank created it upon its books by ledger entry. Further, he freely admitted that no United Redemption Manual, 4.5 edition 185.
Grab the documents, of course.
State's law gave the bank the authority to do this. There was obviously no lawful consideration for the note. The bank parted with absolutely nothing except a little ink. Note, it has never been doubted that a note given in a consideration which is prohibited by law is void. It has been determined, independent of acts of Congress, that sailing under the license of an enemy is illegal. The admission of bills of credit upon the books of these private corporations, for the purposes of private gain is not warranted by the Constitution of the United States and is unlawful. No complaint was made by the banker that the bank did not receive a fair trial. From the admissions made by Mr. Lawrence V. Morgan, the path of duty was clearly made and very direct and clear for the jury. Their verdict could not reasonably have been otherwise. Justice was rendered completely and without denial, promptly and without delay, freely and without purchase, comfortable to the laws in this court on December 7, 1968. The following pages present the rulings for the original pleading, the appeal, and the testimony given at Mr. Jerome Daley's disbarment proceedings brought by the Minnesota State Board of Law. Justice Martin V. Mahoney, who heard the case, handed down the two opinions attached and included herein. The appeal's determinations are by far the most stunning. Its reasoning is sound. It will withstand the test of time. This is the first time the question has been passed upon in the United States. I predict that this decision will go into the history books as one of the great documents of so-called American history. It is a huge cornerstone wrenched from the temple of imperialism, money kings, and planted as one of the solid foundation stones of liberty. Forward by Associate Justice Bill Drexler. The Credit River decision handed down by a jury of 12 on a cold day in December, in the Credit River Township Hall, was an experience that I'll never forget. The Chief Justice of the Minnesota Supreme Court had phoned me a week before the trial and asked me if I would be an Associate Justice in assisting Justice Martin V. Mahoney since he had never handled a jury trial before. I accepted, and it took me 2 hours to get my car running in the 22 below zero weather. I got to the courtroom about 30 minutes before trial, and helped get the wood stove going, since the trial was being held in an unheated storeroom of a general store. This was the first time I met Justice Martin V. Mahoney, and I was impressed with his no-nonsense manner of handling matters before him. My job was to help pick the jury, and to keep Mr. Jerome Daly and the attorney representing the Bank of Montgomery from engaging in a fist fight. The courtroom was highly charged, and the jury was all business. The banker testified about the mortgage loan given to Mr. Jerome Daly, but then Mr. Jerome Daly cross-examined the banker about the creating of money out of thin air. Mr. Jerome Daly asked the bank president, if you were just opening up your bank and no redemption manual, 4.5 edition 186. One had yet made a deposit, and I came into your bank, and wanted to take out a loan of $18,000, could you loan me that money? When the bank president said, yes, I thought the jury would faint. Mr. Jerome Daly then said, does this mean that you can create money out of thin air? And the bank president said, yes, we can create money out of thin air. Justice Martin V. Mahoney then said, it sounds like fraud to me, and everybody in the courtroom nodded their heads indicating that they agreed with Justice Martin V. Mahoney. I must admit that up until that point, I really didn't believe Mr. Jerome Daly's theory, and thought he was making this up. After I heard the testimony of the banker, my mouth had dropped open in shock, and I was in complete disbelief. There was no doubt in my mind that the jury would find for Mr. Jerome Daly. Mr. Jerome Daly had taken on the bankers, the Federal Reserve banking system, and the money, kings, lenders, and had won. It is now 28 years since this landmark decision, and Justice Martin V. Mahoney is quoted more often than any Supreme Court justice ever was. The money, kings, boys that run the private Federal Reserve Bank soon got back at Justice Martin V. Mahoney by poisoning him in what appeared to have been a fishing boat accident, but with his body pumped full of poison, in June of 1969, less than months later. Both Mr. Jerome Daly and Justice Martin V. Mahoney are truly the greatest men that I have ever had the pleasure to meet. The Credit River decision, as it is known, was and still is the most important legal decision ever decided by A.J. Y. Bill Drexler. Note, Bill Drexler was subsequently disbarred for his role in the Credit River case. 2222222 Redemption Manual, 4.5 edition 187. In District Court State of Minnesota County of Scott 1st Judicial District 1st National Bank of Montgomery, Minnesota, Plaintiff, versus Jerome Daly, Defendant. The above entitled action came on before the court and a jury of 12 on December 7, 1968 at 10 a.m. Plaintiff appeared by its president Lawrence V. Morgan and was represented by its counsel Theodore R. Miubetti. Defendant appeared on his own behalf. A jury of talesmen were called, empaneled, and sworn to try the issues in this case.
Let's hold up right there, because I want to look at some of these people. First, let's see what the Wikipedia says about the case now. First National Bank of Montgomery versus Jerome Daly, December 9, 1968, Justice Court, Credit River Township, map pop up, Scott County, Minnesota, also known as the Credit River case, was a case tried before a Justice of the Peace in Minnesota in 1968. The decision in that case is sometimes cited by opponents of the United States banking system. The Federal Reserve System is the central banking system of the United States of America. It was created on December 23, 1913, with the enactment of the Federal Reserve Act after a series of financial panics led to the desire for central control of the monetary system. All right. So the Federal Reserve System is the United States banking system according to Wikipedia. So the trial. An attorney named Jerome Daly was a defendant in a civil case in Credit River Township, Scott County, Minnesota, heard on December 9, 1968. The plaintiff was the First National Bank of Montgomery, which had foreclosed on Daly's property for non-payment of the mortgage and was seeking to evict him from the property. Right? Daly based his defense on the argument that the bank had not actually loaned him any money, but had simply created credit on its books. Daly argued that the bank had thus not given him anything of value and was not entitled to the property that secured the loan. I put emphasis on those words so that I remember and so that you, um, if you watching this shit, as I'm talking like somebody's gonna be watching this shit, funny as hell. Secure the loan. Alright. The jury and the justice of the peace, Martin v. Mahoney, agreed with this argument. The jury returned a verdict for the defendant, and the justice of the peace declared that the mortgage was null and void, and that the bank was not entitled to possession of the property. All right. The jury and the justice of the peace, Martin Vincent Mahoney, was a Scott County, Minnesota justice of the peace who presided over the initial trial in the case of First National Bank of Montgomery versus Jerome Daly. See if they got an image of him anywhere. No images. shows up, other places that it shows up, and then you get relatively current, you know what I mean, comments. Coming back to that, but let's continue on.
Lawrence v. Morgan was the only witness called for. Plaintiff and defendant testified as the only witness in his own behalf. Plaintiff brought this as a common law action for the recovery of the possession of Lot 19, Fairview Beach, Scott County, Minnesota. Plaintiff claimed title to the real property in question by foreclosure of a note and mortgage deed dated May 8, 1964, which plaintiff claimed was in default at the time foreclosure proceedings were started. Defendant appeared and answered that the plaintiff created the money and credit upon its own books by bookkeeping entry as the consideration for the note and mortgage of May 8, 1964, an alleged failure of consideration for the mortgage deed, and alleged that the sheriff's sale passed no title to plaintiff. The issues tried to the jury were whether there was a lawful consideration and whether defendant had waived his rights to complain about the consideration, having paid on the note for almost 3 years. Mr. Morgan admitted that all of the money or credit which was used as a consideration was created upon their books, that this was standard banking practice exercised by their bank in combination with the Federal Reserve Bank of Minneapolis, another private bank, further that he knew of no United States statute or law that gave the plaintiff the authority to do this. Plaintiff further claimed that defendant, by using the ledger book, created credit, and by paying on the note and mortgage waived any right to complain about the consideration, and that defendant was stopped from doing so. At 12:15 on December 7, 1968, the jury returned a unanimous
It's
verdict for the
common law
defendant.
action.
Now therefore, by virtue of the authority vested in me pursuant to the Declaration of Independence, the Northwest Ordinance of 1978, the Constitution of the United States, and the Redemption Manual, 4.
Hold up. What is the Northwest Ordinance of 1978? What is the Northwest Ordinance according to Wikipedia? and then we'll get all the source material and look at it ourselves. Northwest Ordinance. The Northwest Ordinance, formerly an ordinance for the government of the territory of the United States northwest of the River Ohio, and also known as the Ordinance of 1787, enacted July 13th, 1787, was an organic act of the Congress of the Confederation of the United States. It created the Northwest Territory, the first organized territory of the United States, from lands beyond the Appalachian Mountains between British North America and the Great Lakes to the north and the Ohio River to the south. The upper Mississippi River formed the territory's western boundary. In the Treaty of Paris, 1783, which formally ended the American Revolutionary War, the War of Independence. The Treaty of Paris was signed in Paris by representatives of King George III of Great Britain and representatives of the United States of America on September 3rd, 1783. Ended the American Revolutionary War. The treaty set the boundaries between the British Empire in North America and, see, the things, you know what I mean, that get missed by not reading, you know what I mean, reading about what this thing is. They don't teach us this shit in history class. You get a edited dictation. All this shit is edited and dictated to you. Short form, you know what I mean, the condensed form. You have to, you know what I mean, want to know more. You have to want to know more. So, in the Treaty of Paris, 1783, which formally ended the American Revolutionary War, Great Britain yielded this region to the United States. Great Britain yielded this region to the United States. However, the Confederation Congress faced numerous problems gaining control of the land. These included what? The unsanctioned movement of American settlers into the Ohio Valley. The unsanctioned movement of American settlers into the Ohio Valley. Violent confrontations with the region's indigenous peoples. The ongoing presence of the British Army, which continued to occupy forts in the region, and an empty U.S. what? Treasury. An empty U.S. Treasury. The ordinance superseded the Land Ordinance of 1784, which declared that states would one day be formed within the region, and the Land Ordinance of 1785, which described how the Confederation Congress would sell the land to private citizens. designed to serve as a blueprint for the development and settlement of the region. What the 1787 ordinance lacked was a strong central government to implement it. This need was addressed shortly thereafter when the new federal government came into existence in 1789. Right? That's why we say, de facto. Mor Amorakan. Amorok. El Morak. Right? Came into existence in 1789. The first United States Congress reaffirmed the 1787 ordinance. Right? Now the law. Let's see. What is an ordinance? Blow it up for my bad eyes. Ordinance. A rule established by authority. A rule established by authority. A permanent rule of what? Action. A law or statute. In a more limited sense, the term is used to designate the enactments of the legislative body of a municipal corporation. State versus Swindle. Bill versus Goshen. I really need to learn how to read case citation, right? That's a part of knowing this language as well. The name has also been given to certain enactments, more general in their character than ordinary statutes and serving as organic laws, yet not exactly to be called, quote, constitutions, unquote. Such was the, quote, ordinance for the government of the Northwest Territory, end quote, enacted by Congress in 1787. Strictly, a bill or law, a bill or law which might stand with the old law and did not alter any statute in force at the time, honest, which became complete by the royal assent. assent on the parliament roll without any entry on the statute roll. So there's a parliament roll and a statute roll. A bill or law which might at any time be amended by the parliament. Funkadelic. I just knee deep. She was totally deep when she did the freak with me. Without any statute. That's hell. Common law. Or something. An ordinary or blah, blah, blah. An ordinance was otherwise distinguished from a statute by the circumstance that the latter required the threefold assent of kings, lords, and commons, while an ordinance might be ordained by one or two of these constituent bodies. See, that's the British shit. Then you have the Ordinance of 1647, which was a law passed by the colony of Massachusetts, still in force in a modified form, whereby the state owns the great ponds within its confines, which are held in what? Trust for public uses. That is from Watupa Reservoir Company versus Fall River. Look up these cases and see what these businesses were. This is 1647, passed by the colony of Massachusetts. Ordinance of 1648 is a law of England. Ordinance of 168L, an ordinance of France. An ordinance of 1787 was the statute for the government of the Northwest Territory. Religious and legal freedom, encouragement of education, just treatment of the Indians, the future division into states, and the exclusion of slavery were ordained. That's from Webster's Dictionary, talking about the Ordinance of 1787 in the fourth edition of Black's Law. I'm sure when we go to the eighth edition, it's going to be something different. Then there's an Ordinance of the Forest. That's also in English law. Ordinances of Edward. All right. Ordinandi lex. Latin, the law of procedure, as distinguished from the substantial part of the law. Yeah, that's what an ordinance is, according to Black's law, right? And we just saw right there in Black's Law Dictionary what the Northwest Ordinance was. I said in the lyrics they're making land grabs, and they was making land grabs. But I mean, who was sanctioning this? This was something that was going on between what? The colonizers and the British Crown. You know what I mean? And also France. You know what I mean? And a whole bunch of other, you know what I mean, uh, countries, so called, of Tamahu, you know what I mean, who was looking for land and resources. You know what I mean? This is what happened when the beasts of the field, Behemoth. This is what happened when Behemoth was loosed. You know what I mean? In the world. Anyway, continuing on.
5 edition 188. Constitution and laws of the state of Minnesota not inconsistent therewith, it is hereby ordered, adjudged and decreed, 1. That plaintiff is not entitled to recover the possession of Lot 19, Fairview Beach, Scott County, Minnesota according to the plat thereof on file in the Register of Deeds Office. 2. That because of failure of a lawful consideration the note and mortgage dated May 8, 1964 are null and void. 3. That the sheriff's sale of the above described premises held on June 26, 1967 is null and void, of no effect. 4. That plaintiff has no right, title, or interest in said premises or lien thereon, as is above described. 5. That any provision in the Minnesota Constitution and any Minnesota statute limiting the jurisdiction of this court is repugnant to the Constitution of the United States and to the Bill of Rights of the Minnesota Constitution and is null and void, and that this court has jurisdiction to render complete justice in this cause. 6. That defendant is awarded costs in the sum of $75 and execution is hereby issued therefore. 7. A 10-day stay is granted. 8. The following memorandum and any supplemental memorandum made and filed by this court in support of this judgment is hereby made a part hereof by reference. By the court dated December 9, 1968 Martin V. Mahoney Justice of the Peace Credit River Township Scott County, Minnesota Memorandum. The issues in this case were simple. There was no material dispute on the facts for the jury to resolve. Plaintiff admitted that it, in combination with the Federal Reserve Bank of Minneapolis, which are for all practical purposes, because of their interlocking activity and practices, and both being banking institutions incorporated under the laws of the United States, are in the law to be treated as one and the same bank, treated as one. Banking institutions incorporated under the laws of the United are for all practical purposes, because of their interlocking activity and practices, and both being banking institutions incorporated under the laws of the United States, are in the law to be treated as one and the same bank, did create the entire $14,000 in money or credit upon its redemption manual, 4.5. Own books by bookkeeping entry. That this was the consideration used to support the note dated May 8, 1964 and the mortgage of the same date. The money and credit first came into existence when they created it. Mr. Morgan admitted that no United States law or statute existed which gave him the right to do this. A lawful consideration must exist and be tendered to support the note. C. Anheuser-Busch Brewing Co. v. Emma Mason, 44 Minnesota 318, 46 NW 558. The jury found there was no lawful consideration and I agree. Only God can create something of value out of nothing. Even if defendant of no found there was no lawful consideration and I agree. Only God can create something of value out of nothing. Even if found there was no lawful consideration and I agree. Only God can create something of value out of nothing. Even if defendant could be charged with waiver or estopped as a matter of law, this is no defense to the plaintiff. The law leaves wrongdoers where it finds them. See sections 50, 51, and 52 of AM Jur 2D. Actions on page 584. No action will lie to recover on a claim based upon, or in any manner depending upon, a fraudulent, illegal, or immoral transaction or contract to which plaintiff was a party. Plaintiff's act of creating credit is not authorized by the Constitution and laws of the United States, is unconstitutional and void, and is not a lawful consideration in the eyes of the law to support anything or upon which any lawful rights can be built. Nothing in the Constitution of the United States limits the jurisdiction of this court, which is one of original jurisdiction with right of trial by jury guaranteed. This is a common law action. Minnesota cannot limit or impair the power of this court to render complete justice between the parties. Any provisions in the Constitution and laws of Minnesota which attempt to do so are repugnant to the Constitution of the United States and are void. No question as to the jurisdiction of this court was raised by either party at the trial. Both parties were given complete liberty to submit any and all facts and law to the jury, at least in so far as they saw fit. No complaint was made by plaintiff that plaintiff did not receive a fair trial. From the admissions made by Mr. Morgan, the path of duty was made direct and clear for the jury. Their verdict could not reasonably have been otherwise. Justice was rendered completely and without denial, promptly and without delay, freely and without purchase, comfortable to the laws in this court on December 7, 1968. By the court December 9, 2 LSI Martin v. Mahoney, Justice of the Peace, Credit RNER Township, Scott County, Minnesota. Redemption. Martin v. Mahoney, Justice of the Peace, Credit River Township, Scott County, Minnesota. On January 6, 1969, this court filed a notice of refusal to allow appeal with the clerk at the District Court, Hugo L. Hentges, for the County of Scott and the State of Minnesota, which is as follows: Notice of refusal to allow appeal to Hugo L. Hentges, Clerk of District Court, Plaintiff, First National Bank of Montgomery, and Defendant Jerome Daly. You will please take notice that the undersigned Justice of the Peace, Martin v. Mahoney, hereby, pursuant to law, refuses to allow the appeal in the above entitled action, and refuses to make an entry of such allowance in the undersigned's docket. The undersigned also refuses to file in the office of the Clerk of the District Court in and for Scott County, Minnesota, a transcript of all the entries made in my docket, together with all process and other papers relating to the action and filed with me as Justice of the Peace. The undersigned concludes and determines that MSA 532.38 was not complied with within 10 days after entry of judgment in my Justice of the Peace Court. Subdivision 4 thereof requires that $2 shall be paid within 10 days to the Clerk of the District Court for the use of the justice before whom the cause was tried. 2 so-called $1 Federal Reserve notes issued by the Federal Reserve Bank at San Francisco L1278283C and Federal Reserve Bank of Minneapolis serial no L804LC697.
Hold on, let me look and see currently what Federal Reserve notes is in my wallet and where they're from. Let's check it out. Alrighty. Now I gotta get my glasses on. Since I bought them, I ain't even trying them out yet. Like talking about. Damn shame. My eyes is running like crazy. Let's see here. We got a Jackson. The number's MB04966423I. Federal Reserve note. With all the security features. MB046643I. Series 2019. There's the Secretary of the Treasury signature. And there's the Treasurer of the United States' signature. This note is legal tender for all debts, public and private. You flip it over. You got the "In God We Trust," White House. Let's see things. Reserve. Got these dubs with this serial number on them. Where were they minted at?
They were deposited with the clerk of the district court to be tendered to me. These Federal Reserve notes are not lawful money within the contemplation of the Constitution of the United States and are null and void. Further, the notes on their face are not redeemable in gold or silver coin, nor is there a fund set aside anywhere for the redemption of said notes. However, this is a determination of a question of law and fact by the undersigned pursuant to the authority vested in me by the Constitution of the United States and the Constitution of the State of Minnesota. Plaintiff is entitled to be accorded full due process of law before the court in this present determination not to allow the appeal. If plaintiff will file a brief on the law and the facts with this court within 10 days, or if plaintiff will file an application for a full and complete hearing before this court on the determination, a prompt hearing will be set, and if plaintiff can satisfy this court that said notes are lawful money issued in pursuance of and under the authority of the Constitution of the United States of America, the undersigned will stand ready and willing to reverse himself in this determination. Take notice and govern yourselves accordingly. By the court dated January 6, 1969, LSI Martin v. Mahoney. Martin v. Mahoney, Justice of the Peace, Credit River Township, Scott County, Minnesota. Memo: I am bound by oath to support the Constitution of the United States and laws passed pursuant thereto, and the Constitution and laws of Minnesota not in conflict therewith. This is an important case to both parties and involves issues, apparently, not previously decided before. It is also important to the public. The clerk of the district court is an officer of the judicial branch of the state of Minnesota. His act is the act of the state. U.S. Constitution, Article I, Section 10 provides no state shall make anything but gold and silver coin a tender in payment of debts. The tender of the 2 Federal Reserve notes runs counter to the fundamental law of the land, the Constitution of the United States of America. It appears on the face of it that the notes are ineffectual for any purpose, and that I am not justified in taking any steps toward the allowance of an appeal in this case. It is, however, the order of this court that the parties are entitled to a full hearing before this court, and, if requested, a full hearing will be granted. Dated January 6, 1969, by the court/S/Martin v. Mahoney. Martin v. Mahoney, Justice of the Peace, Credit River Township, Scott County, Minnesota. Minnesota statutes annotated 532.38 required that the appellant, First National Bank of Montgomery, deposit with the clerk of the district court within 10 days, $2 lawful money of the United States, for payment to the Justice of the Peace before whom the cause was tried. This is one of the conditions for the allowance of an appeal. 1 Federal Reserve notes were deposited with the clerk of the district court. One was issued by the Federal Reserve Bank of San Francisco, bearing serial No. L127828836 and the other on deposit was issued by the Federal Reserve Bank of Minneapolis bearing serial No 180410697A. This court determined that said notes on their face were contrary to Article I, Section 10 of the Constitution of the United States and also based upon the evidence deduced at the hearing on December 7, 1968, the notes were without any lawful consideration and
Article 1, Section 10 of the United States Constitution. Let's check it out. Article 1, Section 10. Article 1, Section 10 of the U.S. Constitution. U.S. Constitution down there, we just grab the first shit that pops up. Cause there's a pop up. There's a pop up. How much time we got? Where we at? Alright, we'll wrap it up with this. U.S. Constitution, Article 1, Section 10. Article 1, the legislative branch. Section 10, powers prohibited of states. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. No state shall, without the consent of the Congress, lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws, and the net produce of all duties and imposts laid by any state on imports or exports shall be for the use of the Treasury of the United States, and all such laws shall be subject to the revision and control of the Congress. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops, or ships of war in time of peace, enter into any agreement or compact with another state, or with a foreign power, or engage in war, unless actually invaded, or in such imminent danger as will not admit of delay. That is it. And that is it for right now. They make it out of thin air, y'all.